So it's a pleasure to be here today. I was really honored when I was asked to come. Can everyone hear me? Okay, and can you hear me on the microphone because they're recording it? Okay, great. So I'm going to talk about privacy matters, and there's a double sense there, like things having to do with privacy and why privacy matters. Let me start by letting you in on a little secret. Privacy matters matter. So I'm going to talk a little bit about when privacy goes bad and give you some examples. We'll talk about different cases that have occurred. We'll talk about some of the work that we've done in analyzing privacy practices of companies, and talk a little bit about how we go about doing that. How do you look at the privacy practices of a company, and how does that line up with what we as consumers care about and want to see in privacy practices and in privacy policies, and what are we concerned about? And then I'll also talk about other studies that we've done where, for instance, we've done an empirical study looking at perceptions versus comprehension of privacy policies. And then in terms of what matters next, the next step is looking at regulatory compliance, and I'll give a brief overview of that. So why do we care about privacy? Well, a lot of what we do in society today involves the exchange of information, whether it be government, healthcare, our financial information, et cetera. And in order for us to be willing to take full advantage of these services, we really need to trust the systems that we work with, and we need to understand how our privacy is being protected. So let's look at a glimpse of the future. And this is a video I'm going to play, and I hope that you will hear it. We have these sturdy little speakers here.
Pizza Palace, guaranteed hot in 30 minutes, or it's free. This is Mary. May I take your order?
Hi, Mary. Yes, I'd like to order.
Is this Mr. Kelly?
Yes.
Thank you for calling again, sir. I show your national identification number is 610-204-9998-45-54610. Is that correct?
Yes.
Thank you, Mr. Kelly. I see you live at 736 Montrose Court, but you're calling from your cell phone. Are you at home?
I'm just leaving work, but I'm...
Oh, we can deliver to Bob's Auto Supply. That's at 175 Lincoln Avenue, yes?
No, I'm on my way home. How do you know all this stuff?
We just got wired into the system, sir.
Oh, well, I'd like to order a couple of your double meat special pizzas.
Sure thing. There'll be a new $20 charge for those, sir.
What do you mean?
Sir, the system shows me that your medical records indicate that you have high blood pressure and extremely high cholesterol. Luckily, we have a new agreement with your national health care provider that allows us to sell you double meat pies as long as you agree to waive all future claims of liability.
What?
Do you agree, sir? You can sign the form when we deliver, but there is a charge for processing. The total is $67 even.
$67?
That includes the delivery surcharge of $15 to cover the added risk to our driver of traveling through an orange zone.
I live in an orange zone?
Now you do. Looks like there was another robbery on Montrose yesterday. You could save $48 if you ordered our special Sprout Submarine Combo and picked it up yourself. Comes with tofu sticks. Those are very tasty, sir. Good value, too.
But I want double meat.
Well, I'm sure you can afford the $67 then. You just bought those tickets to Hawaii. They weren't cheap, eh? Oh, but I see you checked out the budget beach bum at the library last week. Up to you, sir.
All right. I'll get the Sprout subs.
Good choice, sir. Gotta watch that waist if you're hitting the beach, eh? 42 inches. Wow. Man, I think tofu and Sprouts is like required.
That's how much?
Just between you and me, there's a $3 off coupon in this month's Total Men's Fitness magazine. Your wife Betty subscribes to that, right? Anyhow, clip that and it's $19.99 even. Whoa, looks like you maxed out on all your credit cards. Bring cash, okay?
Want to stop this from happening?
So we laugh. We're not quite there yet, but there are a lot of places where they have a lot of information about you that you may not be aware of. So this was actually a video that was put out by the ACLU, and it's available on YouTube if you're interested. So, and a special shout out to my student, Jeremy, who converted it to an AVI file so I could actually include it here today. Oops, now I'm going the wrong thing. So let's continue. So why is privacy so difficult? Well, it's challenging because privacy means different things to different people. So some of the things that you maybe saw in that clip may not bother you. Personally, they bother me, but some people don't care about things. Like maybe you don't care if people know what size clothes you wear or where you went to vacation. But I think in general, once you start aggregating a lot of this information into a complete picture, it's a little scary. So it depends a lot about the parties that are involved. So you don't care about your physician having healthcare information about you. But once the pizza place does, that's a little concerning. There are different perceptions, there are different standards across the world The OECD is the European Union standard for data protection. There's the Federal Trade Commission. We have regulations in the United States. But there's no one simple definition that is equally and broadly applied in a uniform manner. And that's what makes it difficult to work in this space. So what happens when the balance is off? We all remember Virginia Tech. This was a really thorny example because it's a very sensitive case. We have laws in place that protect student information at a university, and yet we know that when we're working with mental health, there are different dangers that are imminent in cases like this. And so there is no one right answer. And unfortunately, we have to learn from these cases and hopefully move forward. And closer to home, for those of you who've been around a long time, you may remember that we had a murder-suicide here at NC State. And for me, it hit really close to home because both of those students were in my class that semester. And so how do you handle situations like this? Like, what could we have done differently, and how much information can we make available? And what can we do to help students trust us more to be able to help them? If we had the proper information, maybe we could have prevented this from happening. So those are the thorny, bad cases and the things that we want to get to a point where we can prevent. So let's think about privacy on the university campus. So how many of you have heard of FERPA? Okay, if you're a student, by golly, you should know about this because this governs your student records. So FERPA was enacted in 1974, and basically it means that the following is considered public unless you otherwise specify it to your university. So your name, your phone number, email address, major, et cetera. Okay? But in order to be released to third parties, you have to provide consent for that to happen. Okay? So basically, though, it protects your educational records. So this is why if your parents send you to college, then they can't see your grades unless you consent to it. Right? So for those of you who are parents and you're paying for your students' education, I encourage you to make sure that your students know that you're going to be getting the grades, because if you're paying for it, you should. But if you're paying for your education, then maybe your parents don't need to see your grades. So what are the rights you have? You have the right to inspect and review information contained in your educational records. I'll just touch on a few of these. You have the right to prevent disclosure with certain exceptions about personally identifiable information about you. You have a right to secure a copy of your institution's policy, and there's an address that you can write to from the Department of Education should you have any concerns about your federal rights. In addition to that, we have HIPAA, which is the Health Insurance Portability and Accountability Act, and that mandates some new rules for medical records on university campuses. And complying with HIPAA is not easy. If you do, we did a search on HIPAA compliance on the web, on Google, and the first thing we saw says, our software fully complies with all HIPAA regulations. And the very next one said, there is no such thing as HIPAA compliant software. So what are you to do, right? It's challenging. And yet we know that compliance with HIPAA is really important. So we know that there are medical conditions that have some stigma associated with them, that patients are willing to pay out of pocket to not reveal information about themselves and to make sure that something doesn't get on their permanent record. We know that when patients go to physicians, they don't fully disclose what they have because they're afraid of that stigma that might be associated with it. And then what happens is that the physician can't properly diagnose what the actual problem is because they don't have a complete picture of the patient's record case. And that's what we want to try to prevent. But while patients don't feel comfortable and trust the system, they're not going to do this. And so this is affecting the way that we deliver healthcare in this country. And this is what we don't want to happen. So you don't want to go and say your DNA doesn't match your credit history. Sorry, you're out of luck. And we have legitimate concerns about healthcare privacy in the U.S. So there was a GAO report, Government Accounting Officer report, that showed that 40% of federal health insurance contractors and state Medicaid agencies reported a privacy breach involving personal health care in the past 2 years. So not good. In addition, recently George Clooney had a motorcycle accident, went to the hospital, and turns out 27 people actually accessed his record, 27 people who weren't authorized, had no need to, but heard George Clooney was in the hospital and wanted to check it. And it's a violation of HIPAA, and they were suspended. Those individuals are suspended. So we're starting to see that things are happening, and there are people being held accountable for complying with the law, and that's good. We also have this growing genetic underground where people pay for their own genetic tests because they don't want to share the results with insurers, and they don't want insurers to find out that they might have a pre-existing condition. And so while these things are taking place, then it suggests that we don't feel secure, and we don't feel that we can trust the systems that we have in place. And if you think maybe we're being we're exaggerating about that concern, so Blue Cross Blue Shield last year sent out letters to physicians with the applications of people who were applying for insurance. And they sent email to those people's physicians to see whether or not they had fully disclosed all of their pre-existing conditions. And fortunately, the physician said, absolutely not. This violates patient-physician confidentiality. But these are the types of things that are happening which suggest that maybe we do have reason to be concerned. And then in addition to that, consider that we've had data mining for anti-terrorism. We are experiencing passenger name record sharing with the Department of Homeland Security and Transportation Security Agency. We have had lots of data thefts and data breaches with ChoicePoint, Bank of America, and many others. And so all of these have provoked a lot of public dismay and are perceived as violations of privacy. So what if we were to ask questions about an organization's privacy policies, and specifically NCSU? So in the interest of full disclosure, we've developed a bit of a reputation in our group of analyzing privacy policies of different companies, and when I go someplace to give a talk, I do an on-the-fly analysis, and so I figure if I do it everywhere else, I might as well do it to NC State too. So here's a little quick analysis that I did today. So when we talk about transparency within the legal community as it relates to online privacy, the definition that's often used is this one from Hunton and Williams, which is one of the foremost privacy legal firms in the country. And so they say that transparency requires privacy notices that are easy to understand, facilitate comparison, and are actionable. So keep that in mind as a frame of reference as we discuss privacy policies. So I did a search on HIPAA and NCSU. And I found that, well, this is great. We have a policy at NC State that's privacy and confidentiality of individually identifiable health information. So that's great. And then I noticed that the contact info is the NCSU privacy officer. I was like, wow, we have a privacy officer. That's just great, because I've been wanting to know who that was for a really, really long time, and I've never been able to find that person. So then I did a search on NCSU privacy officer, and I found this page. So this is NC State Student Health Services, and way down at the bottom it says, to request additional information or report a problem, students and non-student patients may contact the NC State's privacy officer so the grammar's even bad, at 919-515-6122. So guess what I did? I called the number. So I called the number, and it was lunchtime, so I got a voicemail. And so I didn't quite I understand the guy's first name was Jim. So I did a search on Jim and the last four numbers and his phone number, and then I found that he's actually really an employee here. And his name is Jim Simple. Some of you may know him. And he is the Director of Insurance and Risk Management and Environmental Health and Safety Center here at NC State. Now, does it say Chief Privacy Officer?
No.
No. And does this suggest that maybe he only knows about insurance?
Yes.
Right. Okay, so that's not good. Okay, I didn't call Jim back once I found out who he was, because I figured he probably wouldn't be able to answer my questions. So then I looked at NC State's privacy statement, which I looked at a couple years ago, and it really hasn't changed much. So here, it's basically a disclaimer. There are certain things that should be expressed in a privacy policy, like what information is being collected, how it's being stored, who's it shared with, do you collect IP addresses, do you use cookies, et cetera. None of that's in our privacy statement. So it's just a disclaimer about, it's state institution, public records, yada, 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 right? And is there a phone number for the Chief Privacy Officer? No. There's a link to the Office of Legal Affairs. So I went to the Office of Legal Affairs and found this. Does this say anything about privacy? No. Is it the same number, the same contact as the previous Chief Privacy Officer? No. So I did a reverse phone on that phone number, since that was the phone number for the main NC State privacy policy. And I found these two lovely individuals with the same number in the same office in legal affairs for the university. Now, does it say chief privacy officer? No, but these are the people I'm supposed to contact if I have a question about the privacy policy. And do you think that if I have anything to do with HIPAA or the information that, like IP addresses and cookies, that they're going to know anything about that? Probably not. Okay, so students, speak with your administration. This is important. Okay, so the concern is that if there is a privacy breach, it's going to go to legal counsel, and they're not going to understand any of the systems that are in place. And this leaves us vulnerable as a university. So then I thought, well, if there's no chief information officer, no chief privacy officer, I know we recently hired a CIO, and this is something that clearly the CIO should be plugged into all this stuff. And so it looks here, if you look, it says the new CIO will direct the work of more than 300 professional and support staff and oversee a budget of in excess of $40 million. He will have overall responsibility for research, academic, and administrative IT activities, which historically have been collaborative but organizationally separate NC State. Okay, so the concern here is, remember, this is information technology. These are the systems that have to comply with policies and regulations. And so there seems to be a disconnect. So here are my recommendations for the future at NC State. And this is something that how many of you are on student government? Yay, okay. We need resolutions coming from you guys. Okay, so we need to strive for more transparency. So we need more than just a simple disclaimer, legal disclaimer on our webpage. We need to be transparent about what we collect, for what purpose we collect IP addresses or use cookies, for instance, for how long, how's the information stored, is it secure, what are retention policies, et cetera. And also we need to ensure that we have, is this in the way? Sorry, I just noticed that. So we also need to ensure that we have coherence and coordination across the campus units, and we've already identified 3. So we have the CPO, who isn't really a CPO, legal affairs, and the CIO. So those of you who are students, run with this. Let me know if you need help. Okay, so privacy is a grand challenge. And it has been identified as such during a Grand Challenge conference that was held by the Computing Research Association a few years ago, where they brought together leaders in the field of security to discuss this. And so the grand challenge that we identified was, for the dynamic and pervasive computing environments of the future, give end users security they can understand and privacy that they can control. How many of you feel that you understand security online when you're on the web? Yeah, that's what I was afraid of. Okay, so you see, it really is a grand challenge. It sounds easy, but it actually isn't. So why we want to make sure that we avoid the pain of leaving these things for later. If we design security and we make it understandable, we'll solve a lot of our problems, and we'll help people make good decisions about to whom they entrust their information, et cetera. So it used to be that on the internet, no one knew you were a dog. Okay. So this unfortunately dates me, because I remember when this came out, and we now have like generations that have never seen it before. But they may have seen this next one, which is what it's like today. So today, not only do they know you're a dog, but they know that you're a 4-year-old German Shepherd, that you like to shop for rawhide shoes, that you visited Lassie's website 213 times, that you think the third Lassie is the hottest Lassie, and that you downloaded photos of that Lassie, and that you've emailed them to 5 other dogs whose identities are. Okay? So you see how the world is changing. So given that, consider that we have this digital competence index, which shows the way that the public feels in terms of what their anxiety level is about how confident they are in the digital infrastructure of our country. And so what we see is that we have a score of 57. That's the confidence index. That's out of 100. That's not good. Okay? And if you look at these little green bars, this is how secure we believe the network is, okay? Which is abysmal. And yet, what do we do online? Look at all these wonderful things that we can do online. We have blog platforms. We've got Facebook. We've got social networks, peer-to-peer things, documents, videos, and all this. And just the other day, despite the fact that we don't trust that these are secure, we freely provide our information to these things. Okay, it's really scary. And just the other day, I think it was like a week or two ago, there was a news item, I don't know if it was a national news or local news, about how teens are using P2P software to exchange files with their friends, videos, etc. And they are downloading these peer-to-peer software apps from different places that aren't really places that we would probably advocate downloading this kind of software from, but they don't know that. And so what was happening is that people in foreign countries were then being able to use that to obtain their parents' tax records. So they knew exactly how to, use the software to then break into their parents' system and to get their tax records. So I don't have my tax records anywhere on my machine, by the way. And I encourage parents to go and check to make sure that your kids know what they're doing if they're using your machine. So anyway, points out this conflict that we have of not trusting and yet trusting blindly.
There was another case a couple of weeks ago with the same kind of thing, and it was someone in the security agency downloaded it and all the details of Obama's
helicopters. Yeah, so Obama's, the Marines had these blueprints for new helicopters for, as you know, the helicopters transport the president around for short distances, and those showed up on a machine in Tehran, not exactly where we want those to be, and it was through peer-to-peer software. So be afraid, very afraid. Okay, so let's talk about a couple of examples when things go wrong. So I don't know if any of you remember the JetBlue data breach that happened a few years ago. So right after 9/11, the Department of Homeland Security and the Transportation Security Administration were very interested in trying to figure out ways that they could identify potential terrorists so that we could prevent another 9/11 from happening. So what happened was that, this is really complex, I'm going really quickly through it. There was a subcontractor of the Department of Defense who got another subcontractor to pilot and test some software to be able to identify potential terrorists. They then contacted the TSA that asked JetBlue and many other airlines, but JetBlue was the only one that actually provided them. JetBlue then provided, I think it was like 5 million passenger name records to Torch Concepts, which is this defense contractor. And then Torch Concepts went to Axiom, which we'd never heard about till then, which is a data broker, and asked Axiom for records on those 5 million people. And then they used that to try to identify potential terrorists. And there was a lot of problems with this. It violated JetBlue's policy. It was investigated by the Federal Trade Commission and the Department of Homeland Security. There was so much anomalous data, and the integrity of the data was so inaccurate that people were misidentified as potential terrorists, and that's when we start getting into problems, and these are the things we want to prevent. So what's interesting about this is when we did this analysis, we realized this is just a mess. Look at all the people, all these information, and wouldn't it be neat if you were a company and you had kind of something you could overlay over your process to say, if we'd had this little overlay, we would have known that we shouldn't have done that was a violation of our policy. And so what we're looking at this from the computer science perspective is how do we implement systems that will prevent this unlawful or non-compliant activity from taking place. So that's one case. And another study we did was of the ChoicePoint data breach. So ChoicePoint had a data breach. It's a complicated story, but this is another data broker, and they collect all of this public record information, and then they share it, sell it, to a lot of other people. So typically to law enforcement for checking someone's employment history to make sure whether they are actually employable, whether they've broken the law, et cetera. And the interesting thing about this one was this was a landmark case with the Federal Trade Commission. So there was a $10 million landmark fine to ChoicePoint for their violations of their privacy policy for unfair practice and all that good stuff. And then they also had to set up a $5 million consumer redress fund for helping people deal with identity theft that happened as a result of the data breaches. And in addition to that, all told, at the end of this process, ChoicePoint ended up spending just under $28 million in between the FTC sanctions and their redesign of their business practices and redesign of their and implementation of their systems to ensure this kind of thing wouldn't happen in the future. That would have drowned many a company, especially in today's economy. ChoicePoint was lucky that it was a huge company and had the resources to survive this. And to their credit, they've really done a good job of changing their practices. They've dropped customers that didn't want to abide by their new, more rigorous standards. They're redacting information rather than providing Social Security numbers in the reports. They only provide the minimum necessary information. So, but this was a landmark case, and they've become a good citizen in the country now in terms of providing a good example. So online, how do you assure the public? So how do we assure that policy complies with law? How can policies be associated with data to ensure that it survives system boundaries, so that when I have a policy that I want NC State to use this information for this purpose, and then NC State might share it with someone else. Let's say they share it with the Alumni Association. Let's say admissions share something with the Alumni Association once I graduate. But I said I didn't want to get email or mail. You know, does that survive the boundaries, for instance? And then how do we support different social and legal definitions of privacy? So how do we analyze privacy practices? And what we've done in my group is that Dr. Bitzler mentioned that my research at Georgia Tech, my dissertation was on goal-based requirements analysis. And so we use strategic and teleological models, which are goal hierarchies in a way, to analyze privacy practices of companies. And so the way we would do this is that we are basically extracting goal statements from privacy statements online. So this is a statement from, I think it was Eckerd Drugs, and this is how we go through mining this stuff out. And so we do this because we want to do a content analysis, see what kinds of things are companies actually expressing in their privacy policies. And it's really complex. This is 57 different keywords that we see in privacy policies. And so to be able to appropriately manage them, we developed a tool, and we have heuristics for which words mean what, and how, so that we can then compare different companies' practices against one another. And then once we have all of these policy goal statements, we then classify them as either protections, which map to the Fair Information Practice Principles from the 1974 Privacy Act here in the States, or they express vulnerabilities, and we classify them accordingly. So we do this to then see what kinds of things are expressed in policies, and here's some examples. So for instance, for choice and consent, there might be something that opt-in to controlling whether you have your personally identifiable information stored or not. Okay. Enforcement and redress, things like disciplining associates or employees who violate privacy policy. Okay. And I mentioned the George Clooney case. There's an example of redress. And then some potential invasions, collecting children's names and ages when they enter contests, which is a clear violation of COPPA, by the way, which is the Children's Online Privacy Protection Act. Transfer of information when your information is shared with third parties, there's a potential for privacy invasion there. And then we have a tool that we developed to support this process. So given that we've analyzed over 100 privacy policy documents in our research group, then how does that content analysis relate to what individuals care about? And so we did a survey, developed a survey instrument, and we ran a survey with, in 2002 with over 1,000 internet users. And what we found is that what consumers are most concerned about, what they most want to see expressed in privacy policies, are information transfer, notice and awareness, and information storage. And yet, what the policies emphasize are data integrity and security, information collection, and user choice and consent. So there's a complete mismatch on what we want to see and what's actually expressed in the policies. We just reran the survey in the fall, and my student, Jessica, is actually in here. She's analyzing the data now, so we have to have some updated data on this. We're very interested in seeing how people's privacy values are evolving over time to do a longitudinal study. But this is a concern, and the results of this kind of study is of great interest to chief privacy officers, for instance, who really have the best intentions of trying to make the policies tailored to what we care about. Yes? We plan to run it every 5 years. Yeah. And so we're just analyzing, 5 years have passed and we just ran it. So stay tuned for the results of that. Okay, so then, if the slide wants to go forward. So then I'll talk about our next study on user perception versus comprehension. So we ran an experiment where we wanted to test whether, how do people feel about privacy policies and the representations of policies versus what they actually comprehend in them. Okay? So we had 4 different variants that we used. We used the original natural language privacy policy. And by the way, they all begin with, "Dear friends, we really are deeply concerned about your privacy." So you get these warm fuzzies right off the bat, right? And then we had another representation was a list of privacy goals and privacy vulnerabilities, just not in any particular order. Then we had a categorical representation. Remember I talked about the protections and the vulnerabilities. So if you clicked on one of the protections, then it would give you the practices associated with that particular category, and the same for the vulnerabilities. And then finally, we had the original natural language policy, and as you hovered your mouse over the policy, it would pop up the corresponding goal statement for each sentence as you were passed over it. And so we were just trying to see if people understood some of these better than others, since we know that there are challenges with the current way that we present them. And this is just to show we had a block design, we had a control group, we had, it was 3 different healthcare privacy policies. I can't remember what they were, drugstore.com, and Jessica might remember, drugstore.com and Health Central and Novartis. And so one of them had more vulnerabilities and protections, one had equal number of vulnerabilities and protections, and one had more protections than vulnerabilities. And so basically we had a good even split amongst the participants over this, and we had 993 usable responses. So what we found is that users comprehend the natural language policies the least, and yet that's the going standard today. That's what you see everywhere. Simply adding the goal highlights increased comprehension. There was a significant increase in comprehension when the goals were categorized, but across the board, the scores were still surprisingly low, no matter which variant was used. And in terms of perceptions, users believed that they were more secure in sharing their information with websites that use the highlights. They felt that the companies that had the natural language policies with those highlights were protecting their information more. And they also felt that the 2 natural language variants were explained more thoroughly than the alternative expressions. So the challenge is that they kind of like the natural language because they feel that people are being very forthcoming and providing a lot of information, but yet they don't understand them. Okay? So then here we have another misalignment. And so this is an area that needs a lot more work. And it was also one of those cases when you do research and you're like, wow, how do I present this? Because there are real ethical ramifications for how you present this work. Because a company could use this in the wrong way and say, they don't understand it. So we can bury all kinds of stuff in this policy, stuff that we really shouldn't be doing, but we do it. And they will never know the difference because they're not going to read it. They're not going to understand it. So why not go ahead and just have really crappy practices? And that's not what we want to promote. What we want to promote is that people realize that we do care. There are different ways of presenting the information that we can understand. And so we've been really fortunate that CPOs have been pretty receptive to the results of this and are interested in coming up with shorter notices to be able to help with comprehension. Yes?
Did you get any sense of how much duplication there was, like that they're all using the same consultants who are writing the same privacy policies and that the similarity was really high? We see that a lot with other kinds of disclaimers where people seem to take the disclaimers from one website and use that as their model language, and it just kind of perpetuates bad writing.
When we first started doing this research about 9 or 10 years ago, yes, we did, because there were only a few templates online and you could tell they were using them. Nowadays, the lawyers, this was like before they actually had lawyers doing it, they'd have the summer intern do it. Now we've got lawyers doing it, and so they're very different from company to company. And so there will be a lot of redundancy. Now, and the other thing is there used to be one policy document. Now there's 5 different documents that have privacy stuff in them. So the burden on the end user is tremendous for having to actually read all this. And in addition to that, if you're dealing with stuff like HIPAA or GLBA, which is the Graham Leach Bliley Act, you also have a different policy for every state so that it's compliant with state regulations. So So we're not seeing it as much anymore. There's a lot of redundancy just within a company's suite of policies. Okay, so clearly it's in our best interest to protect information. Ernst & Young does a survey every year, and they found that compliance with privacy and security policy and regulations has been the #1 driver for the past 3 years. I should say 2008 also. And companies are increasingly being held accountable for their privacy practices, I mentioned with the choice point case, for instance. So let's talk a little bit about the legal landscape. I'm going to go kind of quickly through this now, but just to give you an idea of the kind of work that we're doing in our group. So I mentioned that compliance is a primary driver. I talked a little bit about the choice point case, which is a violation of the Fair Credit Reporting Act. HIPAA violations are $25K per individual violation. And so we see that law is starting to dictate a lot of the things that we do in software and the requirements that we have to specify and implement in software. And so to be able for a company to be accountable, you have to be able to demonstrate how your policies and your system requirements actually comply with law. And this is new. So the idea here, the legal problem we're having is that what happens is that people specify product requirements, they build their nice systems, and then whoops, they get a legal complaint. Okay? And this is what we don't want to happen in NC State, which is why we want to make sure that we have a chief privacy officer, or at least someone who is the person responsible for privacy of all systems at NC State. But you receive a legal complaint, it's like, whoa, wow, guess we need to go read those regulations to see what we're supposed to be doing. And maybe we need to identify new requirements to our system so that they're aligned. Okay? So that's kind of the conundrum, and that's what we want to avoid. We have had experience with Cisco, where they have actually done a really good job when it comes to Section 508 of the accessibility standard in actually reviewing the regulations, having a community of practice where they collaborate with folks at IBM and at other companies to make sure that they identify the legal requirements for complying with the accessibility standard, and then generating product requirements based on that. And then you design your systems, and then you don't have the legal complaints because you're sure you're complying with the law. And so as software engineers, that's the goal that we want. And there are a lot of traditional software engineering activities and security activities that are very amenable to doing this kind of work. So in software engineering, we do things like analysis, where we talk with stakeholders and we look at all the sources of potential requirements, we model them, we develop a system. And in security, we do things like policy enforcement and auditing. And specifically in requirements engineering, we elicit requirements. When we're doing analysis, we resolve ambiguities and contradictions and omissions. This is key when you're analyzing law, because the law is laden with ambiguities and with conflicts as well. And so you have to be able to resolve these and identify them quickly. And then traceability has been a huge challenge in requirements engineering for years. So tracing from the requirements, the design component to the code. And now we're talking about, not only that, we have to trace back to the policy and the regulation as well. And so we have tools that we can use to support this, but it's still challenging. So moving towards regulatory compliance, the two things that, that we are trying to seek are showing due diligence and meeting a standard of care. So due diligence, as described by, in the Black's Law Dictionary, is that due diligence refers to reasonable efforts that persons make to satisfy legal requirements or discharge their legal obligations. And I'm not going to really focus on standard of care. Let's focus on due diligence. So the idea is, let's say you have a company and you have a data breach. Then if you can prove due diligence, the courts are going to be a lot more lenient on you because you did everything possible. You had due diligence to make sure that you did everything within your means to prevent that breach from happening. And some things are beyond our control. But if you can't show due diligence, then you're going to be in trouble, like Choice Point was, for instance. So we can't do this work alone. We have to work with lawyers, because the lawyers are the ones who actually create these regulations. And they need to understand what we need from the regulations so that we can implement systems. And typically, law states things like rights and obligations. And these are the things that we as software engineers have to be able to codify. That sounds pretty easy, except for once you actually start looking at regulations, it's a little complex. So the right, anything that's in red, this is a statement from the HIPAA. And anything in red is an obligation that we've extracted. So covered entity must provide notice, for instance. And then there are constraints. You have to provide the notice no later than the first service delivery. Okay? And then there are modal conditions. You must do something or unless. Okay? So all of this has to be codified. And then we start formalizing this, and this is where I'm going to kind of gloss over things. And then we can specify all of these as with semantic models. And what's nice about this is that you can query the system to see whether or not what you're trying to do is legal or not. Okay, so by formalizing it. And then the other thing we can do is actually really formalize it, and this is like where you lose everyone. So you can formalize this using Z or description logic. And the reason that this is important is that if you can formalize it, then it suggests that you should be able to automate this one day. Okay, and that's ultimately where we'd like to be. But we have a lot of work that needs to be done. We need to develop new technologies for privacy enforcement and auditing. There's a general lack of awareness of regulation in industry. And we need more comprehensive privacy laws. And I was just on the phone on a conference call where we were discussing that the new FTC chair and Representative Boucher are discussing the need for new privacy laws. So it might be interesting to see what happens in this new administration. Consumers need to be protected from serious privacy threats and vulnerabilities, and we need ways of handling all this in software. So then I'm going to just kind of summarize all of that and make some recommendations and maybe help get you all to think about these issues. So we need to make design decisions that comply with law, and at a minimum that really comply with the spirit of the law. We need to make sure that our policies are aligned with business rules and with the requirements for our systems. We need to foster trust, and we need to increase transparency, and one way to do that is through online privacy statements. We need to establish baseline privacy principles that can be customized and tailored based on local or state or federal law. And we need to provide consumers with informed consent options, and this is a real stickler right now with online behavioral advertising. And the other thing I wanted to note, and I haven't talked about this enough, is you can't do this kind of work alone in splendid isolation as computer scientists working in the ivory tower. So we work with Dr. David Mommer in the College of Management, who's a lawyer. We work with Dr. Julie Earp in the College of Management, who's a statistician and knows how to do social, kind of social science work in terms of how do you set up survey instruments. There's no way that any of this work could have been done without them and with other colleagues that we have as well outside of computing. And so I encourage you, especially as students, to think about when you're trying to solve a problem, work with people beyond your comfort zone, because that's the only way you're going to have all the perspectives you need to be able to solve those problems. Other thing is that I really like this notion of ethical design. And so when you have ethical design and when you design systems so that you have transparency, then you build customer loyalty. You reduce the cost of remediation after the fact, and you enhance your brand. Okay? And I love this quote from Gene Spafford at Purdue. He says, "Quality, respective basic human dignity, and the option of worthwhile choice all provide an image and reality of a reputable and quality firm." And then some more general recommendations are to construct meaningful, readable policies for your websites. So ensure that the policies of your university units comply with the university-wide policy, and that's something we haven't ensured here at NC State yet. Test your policies against a focus group. It's really easy. Don't just get the lawyer to write it and put it out there. If you're going to have a lawyer write it, then have people who are your customers actually evaluating it to see whether they understand it and what do they really care about. Ensure that the people who might be contacted about your policy are trained to answer those questions. I haven't talked about it here, but we did an analysis of airline privacy policies a few years ago. And we had one example, which was Alaska Airlines, which was just fantastic, where we were able to ask questions about the policy of the person who wrote the policy. And it wasn't a CPO, but it was a contractor who was on call worked like 10 hours a week for Alaska Airlines and was on call to handle questions like ours. Fantastic. And we thought, what a great model. Maybe not every company needs a CPO. You just need that one person who's on top of it and knows and is responsible. Okay? That was a great example. But then we went all the way to the other extreme end where that was the good, then we had the bad, and then we had the ugly. And the ugly was United. And that took I think it was 7 different phone calls. It was about 45 minutes being jerked around to the final conversation where we were actually yelled at by the person on the phone in India. I haven't flown United since then, by the way. So that's what you don't want. And one of the reasons, I didn't have time to do it, but I was very curious, what would happen if I were to call and do this kind of analysis here at NC State? Am I going to get the same story from legal office as I am from the chief privacy officer? And are they going to be able to answer all the questions? And so that's a concern. And also just ensure that the people who design your system actually understand the policies that they have to comply with, and make sure that they can implement systems that are policy compliant and compliant with law as well. And I can't give a talk without thanking my sponsors. So my work is predominantly funded by the National Science Foundation, which has been really tremendously supportive of our work. And we work with people at NC State and the College of Engineering, College of Management, as I said, outside of our discipline, and with Purdue University and Georgia Tech as well. And if you have any questions or want more information, there's my URL, and I'd be happy to take some questions.